I'm Dr. Bill Durston. I'm the president of Americans Against Gun Violence. As some of you know, the Sacramento chapter of Physicians for Social Responsibility has held an annual dinner every year for the last 15 years, featuring outstanding keynote speakers. PSR's main focus is the prevention of nuclear war. And PSR is the U.S. affiliate of International Physicians for the Prevention of Nuclear War, which won the 1985 Nobel Peace Prize. PSR is also a member organization of the International Campaign to Abolish Nuclear Weapons, which won the 2017 Nobel Peace Prize. And we had the co-founder of ICANN, it's called, as our keynote speaker a couple of years ago. The National PSR organization had an active gun violence prevention program in the 1990s, but that lapsed into inactivity around the time that George W. Bush became president. Here at PSR Sacramento, though, we have had an active anti-gun violence program for many years, recognizing that there is a continuum between nuclear weapons at one end of the deadly weapon spectrum and handguns at the other end. As the Nobel Peace Prize laureate and former late UN Secretary General Kofi Annan said, "The death toll from small arms dwarfs that of all other weapon systems, and in most years greatly exceeds the toll of the atomic bombs that devastated Hiroshima and Nagasaki. In terms of the carnage they cause, small arms indeed could well be described as weapons of mass destruction." I think, as most people know, the United States is an extreme outlier in terms of the laxity of our gun control laws, the extraordinarily high number of privately owned guns per capita in our country, and as a result, the extraordinarily high rate of gun deaths and injuries in the United States. It's long been the position of PSR Sacramento that the United States should adopt stringent gun control laws like the laws in all their other high-income democratic countries. 1 month after the Sandy Hook Elementary School mass shooting in December of 2012, Johns Hopkins School of Public Health convened a summit that brought together researchers from across the United States and a couple of distinguished individuals from other countries to discuss the gun violence problem. The result of the summit was a publication, a compendium entitled "Reducing Gun Violence in America, Informing Policy with Evidence and Analysis." Quite frankly, I was disappointed with the chapters in this book that were written by the American authors. None of them advocated adopting stringent gun control in our country comparable to the laws in other high-income democratic countries. I was very impressed, though, by chapters written by Rebecca Peters, who had received the Australian Human Rights Medal, which is Australia's highest civilian award, for the key role that she played in getting a complete ban on all automatic and semi-automatic rifles adopted in Australia just 12 days after the 1996 Port Arthur massacre. Philip Alpers of Australia also wrote a chapter called "The Big Melt," describing how Australia melted down, bought back and melted down approximately 1 million guns, long rifles and shotguns. And after that ban went into effect, there were no further mass shootings in Australia for the next 22 years. We brought both Rebecca Peters and Philip Alpers to be keynote speakers here. And after their talks, we were inspired to expand what we were doing with PSR Sacramento to a national level. And we formed Americans Against Gun Violence in 2016. The chapter, though, in the Johns Hopkins compendium that inspired me the most was one written by Dr. Michael North, entitled "Gun Control in Great Britain After the Dunblane Shootings." This chapter eloquently described how, after a mass shooting at the Dunblane Elementary School in 1996, the parents of the victims were able to lead a successful campaign to completely ban civilian ownership of handguns in Great Britain. And Great Britain already had a ban on so-called assault weapons. There hasn't been another single shooting, a school shooting, since the ban went into effect and the rate of gun deaths in Great Britain is currently 1/60th the rate in the United States. It was only in the last paragraph of this chapter that the author, Dr. North, revealed that his 5-year-old daughter, Sophie, was one of the victims in the Dunblane mass shooting. I was able to get in touch with Dr. North last year, and I found him to be truly a gentleman and a scholar. We made arrangements to bring him to the United States to go on a speaking tour this spring, but of course, those plans were thwarted by the COVID-19 pandemic. And while I'm still disappointed that we haven't had the opportunity to meet Dr. North, who prefers to go by the nickname Mick, in person, it's a great honor for me at this time to introduce Dr. North, who will be our keynote speaker today. So with that, I'm going to mute myself and turn off my screen. And Mick, you've got the floor, or the Zoom screen, as it were.
Thank you so much, Bill. I was very disappointed when the pandemic made it impossible for me to come to the US earlier this year. And so I'm delighted to have this opportunity to speak to you now. My involvement in campaigning for stricter gun laws began, as Bill said, in 1996. Back then, I was an academic at Stirling University in Scotland. I was also a widowed single parent bringing up my only daughter, Sophie. At the time, I had no knowledge of nor any interest in guns. But all that changed when Sophie was killed at her school in Britain's worst mass shooting. In this talk, I want to describe what happened in the aftermath of that tragedy and explain how the country reacted by banning the private ownership of handguns within 2 years. The context is clearly the 1990s in Great Britain, but I hope that some of the things I will say will be of relevance to the present day in the US and will strike a chord with your own desire for a safer society. On March 13th, 1996, Thomas Hamilton, a man with a grudge against the local community, walked into Dunblane Primary School armed with 4 handguns and more than 700 rounds of ammunition loaded into high-capacity magazines. He held everything legally. Within minutes, he had fatally wounded 1 teacher and 16 5- and 6-year-old children. Another 10 pupils and 3 other members of staff were injured. All of his victims shot with a 9mm semi-automatic pistol. Hamilton then killed himself with a revolver. Gun homicide was rare in Britain. The deaths at Dunblane accounted for almost a quarter of the country's gun victims that year. And it was no surprise that there was outrage at the violence committed by a man whose guns were all owned legally. Nevertheless, the establishment view seemed to be that no change was necessary. Recently released cabinet papers indicate that by the following day, ministers were discussing the need to resist any pressure to tighten gun legislation. My first thoughts were rather different. I disagreed and believed that changes were essential. Firearms legislation is determined by the UK Parliament at Westminster, with some differences between the component countries. In Great Britain, that is England, Wales and Scotland, these laws permitted the private ownership of guns for which an appropriate reason could be demonstrated. The reasons included target shooting, hunting and vermin control, but excluded self-protection. Owners of guns were required to hold a license issued by a local police force. In the case of handguns and rifles, each individual weapon had to be justified. For nearly 20 years, Hamilton had held licenses for a number of handguns, all used for target shooting at an approved gun club, the only good reason for most handgun ownership in Great Britain. Applications were rarely refused and few licenses were subsequently revoked. Some types of firearm, self-loading and pump-action rifles and shotguns, had been prohibited after a mass shooting in the English town of Hungerford in 1987. Half of the 16 victims had been shot with a semi-automatic rifle, but the others had been killed with a handgun, and the Conservative government at the time failed to do anything about handguns. Traditionally, the Conservatives had close links with the British shooting community, and there were accusations that the response had been watered down because of vested interests. The Conservatives were still in power in 1996, and after Dunblane, the government faced awkward questions about why it had not dealt with handguns previously. They set up a public inquiry, chaired by a senior judge, Lord Cullen, which sought to answer questions about the circumstances that led up to and surrounded the Dunblane shootings, and make recommendations with a view to safeguarding the public against the misuse of firearms and other dangers. This provided breathing space for the government, and no doubt many of its ministers were hoping that in the meantime the public outrage would subside. That didn't happen. Campaigns in support of a handgun ban began almost immediately. The prime motivation of the campaigners was to minimize the risk of another mass shooting. Most thought that a minority sport, target shooting with handguns, was insufficient justification for compromising public safety. Handguns were considered just too dangerous. Hamilton's own history suggested it was impossible to design a licensing system which would ensure handguns were never owned by those who potentially might misuse them. In spite of knowing about aspects of Hamilton's behaviour that called into question his fitness to own guns, the senior licensing officer had felt unable to revoke his firearms certificates. Psychological testing, something favoured by the shooting organisations to eliminate potential so-called madmen, was said by the British Medical Association to have no predictive measure, leading campaigners to conclude that in the interests of public safety, it was better to keep handguns out of all private hands. Like myself, almost all of those who became active campaigners had no prior knowledge of guns. Gun enthusiasts argued that this should preclude us from influencing policy. They said only those with a working knowledge of guns were qualified to discuss the legislation that controlled them, and that advocates for gun control were too emotional and seeking an ill-informed knee-jerk reaction. Yet a more telling knee-jerk response had been the gun lobby's immediate contention that nothing could be done to stop such events. In the meantime, many of the campaigners, especially the Dunblane families, were taking a crash course in gun-related issues by following the evidence at the public inquiry. Among the campaigns, two in particular gained national prominence: a petition launched by a Scottish tabloid newspaper, and another, the Dunblane Snowdrop petition, organised by mothers of young families living in the Dunblane area. Both gained hundreds of thousands of signatures. The enormous achievement of the Snowdrop campaign cannot be underestimated, taking place as it did at a time when a quick click on an online petition site became all that was needed to register support for one cause or another. In the space of 3 months, nearly 750,000 people actually signed petition forms, and there's little doubt that this represented the tip of an iceberg of support. Another new organisation, Gun Control Network, was founded and included parents of victims of both the Hungerford and Dunblane shootings. Its aim was to look beyond any handgun ban and provide a permanent voice for gun control. The campaigns ran on limited budgets and relied mostly on the efforts of volunteers. Crucially, the various activities were closely coordinated through vital links between themselves and with the Dunblane families. Without exception, all the families came to support the aim of a handgun ban and became involved in campaigning to a greater or lesser degree. The families had been advised not to engage with the media until the hearings of the public inquiry were concluded. But once able to do so, we took every opportunity to boost the profile of the campaign. It was critical that the issue was kept alive until changes were made. In a pre-social media era, the press, TV and radio were our prime means of getting the message across. More than anyone else, the families could do this by talking to a media desperate to hear personal stories, but also keen to support what we were trying to achieve. Most national newspapers had called on the government to introduce tighter gun controls. The families learned quickly both how to deal with the media and how to gain unique access to politicians. Parliamentary lobbying became a critical activity. The ongoing national debate ensured that by the time the public inquiry report was published 7 months after the shootings, most groups and political parties had already established their positions. Lord Cullen didn't endorse an outright ban on handguns, but did recommend changes, including restrictions on how handguns were kept, suggesting measures such as disablement of guns when not in use and locked barrel blocks. He went on to add that if such a system is not adopted, the government should consider restricting the availability of self-loading pistols and revolvers of any caliber by banning of the possession of such handguns by individual owners. He also commented on the growth of activities like combat shooting and said that its trappings caused others to feel uneasy about what appears to be the use of guns as symbols of personal power. The government delayed announcing its position until the report was published, though the main opposition parties had already declared themselves in favour of a total ban. The Conservatives were weak, with a very small parliamentary majority, divided on a number of issues and facing an imminent general election. Its own MPs would have been sensitive to the public mood reflected in the campaigns, but for too many, this appeared to be offset by their traditional links to the shooting community. So the government opted for a compromise. Going further than Cullen's recommendations, ministers proposed a partial ban prohibiting all large caliber handguns, but not the small caliber ones used for events like the Olympic Games. These were still permitted with tighter restrictions. It was, however, a compromise that satisfied neither the campaigners nor the gun lobby. And in Parliament, the government faced opposition from both sides of the argument, with some MPs, mostly from its own party, opposed to any kind of ban, while the opposition was pushing for complete prohibition. Through press conferences, interviews and lobbying, the families tried to persuade more politicians to support a complete ban, highlighting the fact that small caliber handguns were also lethal. In the end, the government retained sufficient support for their partial ban, which became law nearly a year after Dunblane. It was a notable, though limited, step forward. Decisively, 3 months later, there was a change of government when the Labour Party came to power. As a result of our lobbying, Labour had made a commitment in its election manifesto to prohibit the remaining small caliber handguns. A new bill was duly passed, this time with limited opposition, and by February 1998, all handguns had become prohibited weapons. The guns were surrendered and destroyed, their owners compensated. Gun ownership is relatively low in Great Britain, and the groups representing the shooters failed to win over the wider public. Some in the shooting community had, prior to Dunblane, been concerned by trends in handgun shooting, which might give shooting the wrong image, but eventually they united to oppose any changes. Their intransigence did not serve them well and made it inevitable that those of us seeking tighter controls would want to ensure that gun legislation was significantly reset. And whilst there has been a sustained attempt to reverse the handgun ban, this has been largely unsuccessful. The only concession was to permit an elite group of Olympic pistol shooters to practice on British soil during a limited period before the 2012 London Games. Prior to Dunblane, there had been no gun control organisation in Britain, and arguments in favour of tighter laws were rarely heard by politicians and never routinely. Advocates, together with groups representing victims, are now accepted as important participants in discussions on firearms, resulting in a far more balanced approach to gun legislation. The Gun Control Network has been invited to give evidence to parliamentary committees as regular meetings with ministers and shadow ministers, and successfully pressed for the introduction of further legislation, which has seen tightened controls over imitation firearms and air guns. At home and abroad, the gun lobby has always sought to discredit the handgun ban with distorted claims about its likely impact on UK gun crime. Those claims remain unfounded. Whilst the precise impact of the ban on gun crime is difficult to quantify, there is plenty of evidence that there are now many fewer guns on Britain's streets. The number of firearms offences is now well under a half of what it was in the late 1990s. Gun homicides have become even rarer. Over the last 6 years, the average number per annum in Great Britain has been 26, a figure below the daily gun homicide rate in the US. And there has been no other school shooting. This contradicts gun lobby predictions that fewer guns would lead to more violence, and it's hardly the picture of a country in the grip of gun crime. The issues here were never clouded by arguments over self-defence and the right to bear arms. Indeed, Cullen's report had unambiguously rejected guns for self-defence. And for most of the British population, the ban remains a positive step which has helped maintain a society that wishes to be as free as possible from the threat of gun violence. The predominant view that guns are part of the problem, not part of the solution, remains intact. The ban generated significant interest around the world and has been cited as an example of what could and should be done to stem gun violence elsewhere. Over the last 2 decades, we've often been asked for our thoughts on the situation in other countries, especially after mass shooting incidents in America. At first, I would comment that there'd be a wish to follow the UK's example, and that lessons from one country would be readily learnt by any other suffering the same atrocity. But after more and more US shootings, and not least after Sandy Hook and Parkland, I've realised I'd been too optimistic. However, although too little has happened, I know it's essential to continue sending the message from Britain that change is not only desirable, but possible. 2 decades on, I remain both proud and amazed at how much was achieved in such a short space of time by groups of people with no prior expertise or experience of campaigning, and with many of us still in the process of recovering from tragic personal loss. At its heart was a spontaneous response to an awful event, focused around a simple message with a simple goal. The key was to make certain that there was never any loss of momentum, that politicians wouldn't be allowed to forget what had happened, nor ignore the views of the public. We succeeded, and I hope, however long it takes for others, that our success will remain an example and hopefully an encouragement and inspiration. Thank you very much.
Thank you, Mick. Again, I'm so sorry that we have to do this by Zoom, because if we were doing this in person, you would be receiving a resounding standing ovation at this point for that incredibly moving presentation, and just for the personal example. And I wish we had tens of thousands of people in this webinar to listen to that message, including our elected leaders. At this point, if people have questions for Mick, if you could submit it via the Q&A little icon down at the bottom of your screen, then Marilyn will relay the questions. While we're waiting for people to submit questions, let me ask you a question, and which I think Mr. Schoenberg will also be interested in. In the United States, gun control opponents claim that the Second Amendment to our Constitution is an analog of the 1689 English Declaration of Rights. And my question is, was the 1689 English Declaration of Rights ever repealed? Did that ever come up when you were considering banning handguns in Great Britain?
It did come up. It came up briefly, I think, at the Cullen inquiry, but I heard very little about it. And interestingly, I think it was brought up by an American who was living in Britain at the time. But I think it had absolutely no impact on the way the firearms legislation is framed and implemented in Britain.
Marilyn, would you like to ask other questions of Mick, either ones that submitted previously or ones being submitted now?
Yes, absolutely. And Dr. North, I just want to thank you so much for being here. And from all of us, our sincere condolences for the loss of Sophie. That is just got to be beyond difficult. So thank you. The first question I would like to ask is, how much monetary compensation did handgun owners receive for turning in their handguns? And did it make a difference whether someone who owned a handgun owned, say, several handguns versus one handgun? Did they get more or less, or how did that work?
I can't tell you the whole full details of that. It was contentious for a time. In fact, the gun lobby at some point said that this is never going to be work because compensation is going to cost too much. But they were submitting highly inflated figures for what the total compensation bill would be. I don't know how much they got. I was told that they were supposed to get the market value of each weapon and some compensation for accessories as well that they were obviously not going to need after they stopped shooting with handguns. The total number of weapons was something of the order of 160,000, I think. I can't, off the top of my head, remember what the total compensation bill came to. But despite having criticism of the Conservative government at the time, they did commit themselves to fully compensating, which certainly helped the process of surrender go smoothly.
I see. Okay, thank you. This is from an anonymous attendee. In this political climate, I imagine he's talking about the United States, what more could we do to truly be effective? It seems like for you, it started at a grassroots level of lots of people, really getting together and doing this.
And that's really all there was to it. As I said towards the end, we had no prior expertise or experience. Yet, I think there were various factors that worked in our favour to achieve success, and it's hard to see how those can sort of all be transferred to another situation in another country with different cultural aspects. I think, to me, it was making sure that no matter how much we were being told, oh, give this a rest, this isn't helping your recovery, that's something that was said to the parents a lot of times, that you won't be able to get over this, it's not helping your grieving, that we just decided we would keep going. And one of the important things was having a group of people who were committed to the same aim. And we could, when individually we were struggling, we could drop out for a while, knowing that there were people who would still carry it on in the same way that we wanted to. I would like to say that we were superb organisers and sort of sat down and planned that this would happen, but it happened spontaneously. And I suppose once it was happening, we wanted to make sure that we organised things so it kept going. But there was something perhaps about the numbers of us involved that allowed a group that didn't fracture to stay together, at least for the period of the campaigns.
I see. Thank you so much for that. I have another question. This is from Vicky Schroeder. First, a comment. Really, thank you for sharing such a personal story. And also, what has become your work in this area. It is an amazing story, in some ways daunting, in what we are working to make this change here in the US. One question, can you describe how much power or influence the gun lobby and industry had at the time in the UK?
Thinking back, I think we overestimated how strong the gun lobby was in Britain. They may well have overestimated their influence as well. It was too easy because they seemed to be the only ones talking to politicians, at least before Hungerford and probably up to the time of Dunblane, to think that they were always going to get their way. I think we were a complete surprise to them. They didn't think that any group would keep on campaigning the way that we did. They are nothing like the gun lobby in North America, although you could see the influence that the NRA were having on some of the arguments that some other groups, particularly ones that were formed immediately after Dunblane, was having. But many of the people who enjoyed shooting came from a traditional hunting background. And handgun shooting was relatively new. It was said to be the fastest growing sport in Britain, something that obviously worried a number of us. But those with most influence probably in the gun lobby were people who shot with shotguns and rifles, and less so with handguns.
I see. Thank you.
Dr. Knowles has kindly agreed to take part in the second half, the second hour. So we'll have opportunity to ask him. People can actually ask him in their own words questions in the second hour. So I think we'll move on now to our next speaker. We're, again, very fortunate to have another outstanding speaker. In 2015, I attended a dinner of what was then called the Law Center to Prevent Gun Violence in San Francisco. And there was a cocktail hour before, and I happened to talk with attorney Anthony Schoenberg. And I said, he mentioned that he had worked on a case defending a large capacity magazine ban at the local level. And I said, oh, great, I'm working on the gun violence problem too. And I'm concerned about the Heller decision, which was in 2008, Supreme Court ruled for the first time in history that Second Amendment conferred any kind of individual right to own a gun. And I said, it didn't make sense to me. And he responded, Heller is an abomination. I remembered that. Other experts have since used the same term, an abomination. I recently got back in contact with Mr. Schoenberg in relation to a pending Ninth Circuit appeals court case. So and he has actually agreed to give us pro bono help in filing an amicus brief in this important case. So it's with a great deal of gratitude and honor that I would like to introduce Mr. Anthony Schoenberg as our next speaker. And go ahead, Don, you've got the Zoom screen.
So thank you very much, Bill. I really appreciate the invitation to speak today. In my mind, I had remembered calling Heller an atrocity rather than an abomination, but I think either adjective fits. So I'm actually going to speak about Heller. That's the topic of my talk. Bill wanted me to talk because Heller is really the seminal, unfortunately, currently the operative Supreme Court case addressing this issue. So in 2008, the United States Supreme Court issued its decision in the case District of Columbia versus Heller. The facts of the case were fairly straightforward. Washington, D.C. had passed a law in the mid-1970s called the Firearms Control Regulations Act of 1975. Among other things, it banned the possession of handguns with certain exceptions, and it also required that all rifles and shotguns be either unloaded and disassembled or bound by a trigger lock. Fast forward 28 years to 2003, and a police officer and gun owner named Dick Heller sued the District of Columbia, seeking to invalidate the law, arguing that it violated his right to bear arms under the Second Amendment of the United States Constitution because it forbade him from keeping a handgun in his home for self-defense. Now, keep in mind, Mr. Heller was not just some random plaintiff. He actually had been handpicked, along with several other plaintiffs, by lawyers from the libertarian-leaning Cato Institute, one of whom was a wealthy former entrepreneur named Robert Levy, who financed the case himself. Ironically, Levy actually modeled his litigation strategy after the legal strategies of Thurgood Marshall, who had successfully led the challenges that overturned school segregation in Brown versus the Board of Education. Now, the federal district court, that is the trial court, ruled against Heller and rejected his interpretation of the Second Amendment. But the Federal Court of Appeal for the District of Columbia Circuit, the DC Circuit, reversed in a 2-to-1 decision and held that the Second Amendment protects an individual's right to keep and bear arms, and that the DC Circuit law violated that right. The case then went to the United States Supreme Court, where Justice Antonin Scalia, in a 5-to-4 decision, affirmed the Circuit Court's decision and ruled in favor of Mr. Heller, striking down those provisions of the Firearms Control Regulations Act of 1975 that had been challenged in the lawsuit. And in Scalia's majority opinion, he concluded that the Second Amendment protects an individual right to possess a firearm, unconnected from service in a militia, and he further held that the Second Amendment protects the right to use a firearm for, quote, traditionally lawful purposes, which Scalia described as, quote, the right of law-abiding, responsible citizens to use arms in defense of hearth and home. And Scalia also took issue with the fact that the law had banned what he referred to as a, quote, entire class of arms that Americans overwhelmingly choose for the lawful purpose of self-defense. And what Scalia meant by that, and he's very explicit in his opinion, is handguns. So before I delve a little bit more into the Heller opinion itself, let me just read to you the entirety of the Second Amendment. It's very short. This is what the Second Amendment says. Quote, a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And let me just read that once again. I think it's worth reading again. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, Justice Scalia famously considered himself both a textualist and an originalist. A textualist is someone who interprets the law based solely on the meaning of the legal text itself, that is, the specific words used in the statute or the constitutional provision, with no consideration given to legislative intent, statutory purpose, or context. An originalist is someone who would interpret the Constitution based on the original understanding of the Constitution at the time it was adopted in the late 1700s. Now, one might ask how someone who is a textualist could find that the Second Amendment protects the right of an individual to bear arms, unconnected from any militia, when the very first clause in the Second Amendment explicitly says that the right is for the purpose of a well-regulated militia, and that it is a right of the people rather than an individual. One might also ask how someone who is a textualist could find that the Second Amendment protects a right to own a gun for the purpose of self-defense in the home, when there is no such purpose mentioned anywhere in the amendment, and indeed the only purpose mentioned is for a well-regulated militia. One might also ask how an originalist could find that the Second Amendment protects an individual's right to possess a handgun, given that at the time the Constitution was ratified in 1791, pistols, which are the type of handgun that Scalia said Americans overwhelmingly choose for the lawful purpose of self-defense, would not be invented for another 100 years. Well, the answer is Scalia engaged in what I like to refer to as legal quackery. First, he gave a highly convoluted and dishonest textual reading of the Second Amendment that effectively reads the first clause, the one about militias, entirely out of existence. And then in an effort to prop up his textual eradication of the first clause, he provides a distorted interpretation of the historical record to try to argue that the words "to keep and bear arms" were intended in the 1700s to refer to individual rights as opposed to the collective rights of the people to bear arms for the purpose of a militia. And to pursue this historical revisionism, in his opinion, he focused not on American history at the time the Bill of Rights was adopted, but rather English history and the adoption of the English Bill of Rights more than 100 years earlier, which had entirely different language and arose in a completely different context than the American Bill of Rights. In addition, Scalia also spent time in this opinion discussing certain political debates that took place approximately 80 years later during Reconstruction in the post-Civil War period, and that had at certain times touched upon the right to bear arms. Now, those debates, which took place more than a half century after the adoption of the Second Amendment in a totally different political context, obviously had little, if any, relevance to the intended meaning of the Second Amendment more than half a century earlier when the Bill of Rights was adopted. And finally, as I'm going to get to in a moment, Scalia grossly ignored binding Supreme Court precedent, which had held that the Second Amendment does not convey an individual right to bear arms, but rather is a right that is solely related to militias. Now, Justice John Paul Stevens wrote a lengthy, meticulously researched, and scathing dissent in Heller, in which he truly took Scalia to task for his intellectual dishonesty. Justice Stevens eviscerated Scalia's absurd reading of the text itself, and I will just read one quote from Stevens' dissent. Stevens said, quote, "Without identifying any language in the text that even mentions civilian uses of firearms, the court proceeds to find its preferred reading in what is at best an ambiguous text, and then concludes that its reading is not foreclosed by the preamble." Stevens also provides a corrective in his dissent to Scalia's misleading historical narrative. Stevens focused not on English history or the Reconstruction period that was still more than half a century away at the time of the Second Amendment's ratification, but rather he focused, as you would expect, on American history during the ratification of the Second Amendment itself. And Justice Stevens' thorough research into the historical record revealed that the discussions about the Second Amendment at the time it was adopted indeed focused on service in state militias, not individual gun ownership. Stevens' dissent also pointed out that Heller violated the bedrock jurisprudential principle of stare decisis. That is the principle that the court should follow its own precedents. And in this case, there was a Supreme Court precedent directly on point. The case United States versus Miller from 1939 was a case in which the Supreme Court had rejected a criminal defendant's challenge under the Second Amendment of his conviction for violating the National Firearms Act of 1934 by transporting a short-barreled, i.e. sawed-off shotgun across state lines. The Supreme Court in the Miller case had clearly and unequivocally interpreted the Second Amendment as only guaranteeing the right to keep and bear arms for the purpose of a militia. And the court had actually provided a lengthy historical discussion showing that when the Second Amendment was adopted, standing armies were disfavored, and it was expected that defense of country would primarily be secured through militias comprised of civilians who were generally required to provide their own firearms. And the court gave numerous examples of state laws from that era establishing such militias. Now, Scalia, in his majority opinion, basically just poo-pooed Miller out of hand, and he argued that it, quote, did not purport to be a thorough examination of the Second Amendment, and he said that we therefore read Miller to say only that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes such as short-barrel shotguns. Well, I'll tell you that if one were to read Miller, which I in fact did yesterday, and then reads the quote from Scalia that I just read to you, you would likely conclude that Scalia and his law clerks never actually read Miller, because Miller does in fact contain a thorough examination of the Second Amendment. Whether it purported to do so is beside the point, because that's exactly what it did. Moreover, Miller's meaning cannot reasonably be read in the very limited way that Scalia claims it can. Before Heller, the Supreme Court had never read it that way, and as recently as 1980, in the Lewis versus US case, the Supreme Court had in fact reaffirmed the widely understood meaning of Miller. And in that case, the Supreme Court stated, quote, "The Second Amendment guarantees no right to keep and bear a firearm that does not have some reasonable relationship to the preservation or efficiency of a well-regulated militia." And the court cited Miller for that proposition and even quoted directly from it. Heller is fundamentally in conflict with Miller, and Scalia's brazen dismissal of Miller was a breathtaking act of judicial dishonesty and a radical departure from precedent. As Justice Stevens said in later years, in reflecting on Heller, Stevens said, quote, "When I joined the Supreme Court in 1975, both state and federal judges accepted the court's unanimous decision in United States versus Miller as having established that the Second Amendment's protection of the right to bear arms was possessed only by members of the militia and applied only to weapons used by the militia." So, if it's not clear, the primary point of my talk here is that Heller was wrongly decided. It is a profoundly dishonest decision that plainly and frankly clumsily misreads the clear text of the Second Amendment, and it inaccurately describes the historical record and brazenly fails to follow established Supreme Court precedent. Justice Stevens is really my guiding light on Heller. And in May of last year, just 2 months before his death at the age of 99, Justice Stevens wrote an article in The Atlantic in which he said that Heller is unquestionably the most clearly incorrect decision that the Supreme Court announced during my tenure on the bench. And keep in mind, Justice Stevens' tenure on the bench was the third longest in the history of the United States, 35 years. Also keep in mind that Stevens was a Republican who was appointed by a Republican president, Gerald Ford. So in the last part of my talk, I just want to talk for a moment about what happened after Heller. Heller was decided in 2008. And because Heller involved a law passed by Washington, D.C., which is under the purview of the federal government, it's not a state, at least not yet, it technically did not apply to state laws. But 2 years later, the Supreme Court confirmed in the case of McDonald versus the city of Chicago that Heller's interpretation of the Second Amendment would indeed apply to laws passed by the states and state municipalities, such as cities and counties. Once McDonald was decided, the litigation floodgates, which had begun to open immediately after Heller had decided, were irrevocably thrown ajar. Indeed, since Heller, there have been more than 1,400 lawsuits filed challenging sensible gun laws. The NRA and other similar organizations have spent millions of dollars litigating to try to overturn common sense firearm regulations enacted by cities and counties and states, typically relying on Heller and arguing that the regulation in question violates the Second Amendment. Now, as dire as that may sound, there actually is good news. The good news is that the vast majority of those legal challenges have been unsuccessful. As offensively dishonest as Scalia's opinion in Heller was, it did contain limiting language that has proven important in deflecting many of the legal challenges raised over the last 12 years. Scalia's decision allowed that the Second Amendment right is, quote, not unlimited, and he further said that it is, quote, not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. He further said that, quote, nothing in our opinion should be taken to cast doubt on longstanding prohibitions on possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. He also strongly suggested at one point in the opinion that prohibitions on concealed weapons would be consistent with his interpretation of the Second Amendment, and he expressly said that prohibitions on what he called, quote, unquote, dangerous and unusual weapons would also be consistent with the Second Amendment as he interpreted it, although notably he didn't say what dangerous and unusual means. One might argue that many guns, if not most, are dangerous and unusual. But nonetheless, those limitations, which some have speculated were included in Scalia's opinion to win the vote of Justice Kennedy, have been important for the legal challenges that followed. In the past 12 years, courts have upheld numerous sensible gun laws of all varieties. And a few years ago, I actually saw a statistic that said more than 90% of the post-Heller challenges to gun laws have failed. I couldn't find a current statistic, but I doubt that the 90% number has changed appreciably since the time I read it. So to summarize the post-Heller litigation landscape, the NRA and its allies have been losing consistently for the last 12 years in the courts, and losing quite badly. And while their litigation record is not quite as pathetic as Donald Trump's over the past several weeks, it's pretty close. Only a small number of these challenges have been successful, and the Supreme Court has shown little interest in getting involved in these cases. In fact, the Supreme Court has declined to review more than 150 petitions for review of cases involving gun laws, and in most cases, they left intact lower court decisions upholding the laws. Nonetheless, over the past 4 years, a significant number of very conservative federal judges were installed, including 3 on the United States Supreme Court. It is possible, if not likely, that the federal courts will start taking a more expansive view of Heller. And indeed, Justice Clarence Thomas, echoing certain conservative commentators, has explicitly said in some dissents from the court's decisions to not grant review that he believes that the lower federal courts are misinterpreting Heller. And I think we are likely going to see sensible gun laws getting overturned in the years to come more frequently than what we have seen in the past 12 years, which is why reversing Heller should absolutely be a long-term goal. Now, to be clear, reversing a Supreme Court decision is no small task. Judicial decision-making is by design intended to involve incremental, not meteoric change. The principle of stare decisis is still a bedrock principle of our jurisprudence, and there are good reasons for that. But bad decisions should get overturned, and in fact, they often, or at least sometimes have throughout our history. And we can start laying the groundwork now for an eventual reversal of Heller by starting to make arguments about its wrongness in high-profile cases. And it's also worth noting that since the time Heller was decided, we have learned more about the historical record, and Scalia's counterfactual historical narrative about the Second Amendment is looking more and more like fiction. And that, among other things, might help ultimately turn the tide over time on this issue. So I'm going to leave you with some final words from Justice Stevens once again. In the article last year in The Atlantic, this is how he ended his piece. He said, quote, "I have written in other contexts that an amendment to the Constitution to overrule Heller is desperately needed to prevent tragedies such as the massacre of 20 grammar school children at Sandy Hook Elementary School on December 14, 2012, from ever happening again. But such tragedies have indeed happened again. In the course of writing the chapter of my memoir that discusses Heller, on October 1st, 2017, a gunman fired from the 32nd floor of a hotel in Las Vegas, killing at least 58 people and injuring more than 500 more who were attending an outdoor concert. I had not yet finished the chapter when another mass shooting occurred, this one involving the death of 26 people, including 3 generations of a single family at a church on November 5th, 2017 in Sutherland Springs, Texas. More shootings have happened since." Thank you very much.
Thank you, Tony. And again, I'm sorry we're not in front of a large group of people in person because, again, you deserve a resounding standing ovation.
Thank you.
Thank you and it's so wonderful to have you on our side. I will, in the 5 minutes remaining here, the original schedule was I was going to give part of the talk I gave at the American Public Health Association, but while we still have you on, we'll just mention, as you said, since McDonald, there was only one Supreme Court case. That was the New York State Rifle and Pistol Association versus New York City on a Second Amendment basis that the Supreme Court accepted, and that was last year. And with basically the gun lobby was challenging New York City's strict regulation on transport of handguns within the city. And we wanted to file an amicus brief in that case, realizing that the Supreme Court would be unlikely to overturn its own decision as recently as 2008. We wanted to make the points that you made, that Heller was wrongly decided and should be overturned. And as I mentioned, I'd met Tony back in 2015, but I lost your business card and I couldn't even remember your name. And so we looked and looked and looked for an attorney who would help us file this brief, and finally found a gentleman in Sacramento, Fred Houston. And at the last minute, we got a brief in making the case that Heller was wrongly decided and the Supreme Court should overturn it. It turned out New York City changed its laws to make the case moot because they were afraid, as you intimidate with the current composition, that the Supreme Court would actually expand Heller if they didn't make it moot. But nevertheless, our brief stands as a document on the Supreme Court docket saying that we know Heller was wrongly decided. From our point of view, it's worse than an abomination. Everything you described, it's literally in creating a constitutional obstacle where none previously existed to the adoption of stringent gun control comparable to the laws in Great Britain, particularly a handgun ban, since most killings in the United States, gun-related deaths, are due to handguns. It's literally a death sentence for tens of thousands of Americans every year. So as I'm not sure I mentioned the fact that you have now agreed to give us pro bono assistance in the Duncan v. Becerra case and filing a brief in that. Could you briefly talk about Duncan v. Becerra and the importance of amicus briefs or amicus briefs in appeals court cases, even though appeals courts can't overturn Supreme Court decisions?
Yeah, absolutely. So Duncan v. Becerra was a challenge to the ban on the possession of large capacity ammunition magazines that was part of Proposition 63, which was enacted by the California voters in 2016. And this was a challenge that was made in a federal district court in the Southern District of California, which is in the San Diego area. And the district court, that is trial court judge, found in favor of the plaintiff in that case, who was challenging the ban, and found that it violates the Second Amendment right to bear arms, relying heavily on Heller. This went up to the federal Court of Appeal for the Ninth Circuit, which is the appellate court here in the West. And in a 2-to-1 decision, the court, with the two affirming votes being one from a Trump appointee, one from a Bush appointee, agreed with the lower court, and also found that the ban on large capacity ammunition magazines violated the Second Amendment. Now, in the Ninth Circuit, we have something called en banc review, which is where the party who loses an appeal in the Ninth Circuit can ask the entire circuit court, that is all the judges on the court, to rehear a case. And the state, who is the defendant in Duncan, did apply or file a petition seeking en banc review. And we think it's highly likely that the court will grant it and will reverse. And part of the reason we believe that is because there was a prior Ninth Circuit case, which is the case Bill alluded to earlier that I handled at my firm about 7 years ago, in which the court had ruled on a similar challenge to a large capacity ammunition ban that had been enacted by the city of Sunnyvale. That case was called FIAC versus Sunnyvale. And the language of the ban in the Sunnyvale case was almost identical to the language in Proposition 63. And yet the judges in the Duncan case decided that they were not bound by the decision of the Ninth Circuit a few years earlier in the Sunnyvale case. I think the Ninth Circuit's, and because of that clear conflict, I think it's likely that en banc review will be granted and that there will be a reversal. The court's reasoning for distinguishing between the Sunnyvale case and Prop 63 was sort of a convoluted rationale that said Sunnyvale is a safe community. It's sort of a more affluent community, so they don't have as much of a need for protecting themselves with handguns and firearms as there might be a need for in other communities. It's sort of a crazy, ridiculous rationale that was not based on any evidence whatsoever, but just basically an ad hoc justification by these judges. So I don't think it's going to stand up. As to Bill's question about amicus briefs, in appeals, in the Federal Court of Appeals and in the Supreme Court, particularly in cases that involve issues of, well, I should say, parties can file what are called amicus briefs in appeals generally. An amicus brief just means a friend of the court. It's when a person or a party who is not a party to the case files a brief to give the court basically its perspective on the issue that the court is going to be dealing with. And in cases that involve issues of intense public importance or public interest, there are often many, many amicus briefs filed on both sides. And certainly in gun cases, there are always, almost always, multiple amicus briefs filed. And so they are important. Sometimes they can provide important complements to the arguments made by the parties to the case. Sometimes they can provide a different perspective, but they are very important, and they're an important part of the appellate process.
Thank you very much. At this point, then, we're going to leave this webinar format and move to a meeting format where we can see everybody's faces and people can hide or unhide or mute or unmute. Now, if you abuse your mute, unmute, Steve Walker, who's the man behind the Americans Against Gun Violence logo, can mute you. So at this point, we're going to leave the webinar. And again, tremendous thanks to both Mick North and Tony Schoenberg, and everybody who'd like to engage in the more interactive format. We'll go to the second hour. You can get up, have a cup of coffee, go to the bathroom, whatever, stretch a bit, and see you in a couple of minutes in the other format. So again, thank you very much.
Thank you, Bill.
All right, we'll sign out. Bye-bye.